It's the half-ass reporting for me. You've seen the headlines, including from TMZ. You've seen the now viral clip of Judge Cannone and her response to prosecutor Hank Brennan's motion. Or should I clarify, Hank Brennan's misinformed, lack of evidence statements. Let's break down exactly what happens the last year and a half of this trial and exactly the reason why Hank Brennan purposely lied on the stand and why Judge Cannone was a little bit dramatic and, dare I say, purposeful with her response. As if Cannone hasn't lived this case for years herself. For those that need a quick catch-up or reminder, Karen Reed here is accused of killing her Boston police officer boyfriend, John O'Keefe, on the evening of January 29th, 2022. The motions and hearings and videos you are seeing right now are out of the current pre-trial motions of trial number 2. Yes, we had a full-ass trial already that ended in a mistrial that had a lot of fuck shit going on with it. I could be here for hours just explaining everything that went on, but we are here specifically to talk about that TMZ article and what exactly Judge Cannone was upset about this past week. The motion creating article headlines now was brought forth by Special Prosecutor Hank Brennan. He was hired by Norfolk County specifically for Trial 2. And just a side note, when we start explaining the timeline, Hank Brennan here has publicly on record stated that he is behind on court transcripts, he didn't watch trial, and he essentially doesn't know every bit and piece of this trial, which is a huge issue. Him being misinformed is the exact reason why we are here where we are today. And this is exactly the reason why we heard him misspeak this past week in the hearing. Brennan's motion is specifically geared towards the ARCCA experts that the feds hire into the investigation of John O'Keefe. It was a company by the name of ARCCA that was hired by federal investigators to see, is it possible John O'Keefe could have been hit by Karen's Lexus SUV? And I'm sure you all remember from trial number 1, it was 2 experts from ARCCA that stated it was physically impossible that John O'Keefe was hit by the SUV, not only because of physics, but also because of anatomy and science. John's body does not match up to the damage of Karen Reed's vehicle. Now that we're caught up, let's go over the brief timeline. On January 24th, 2024, prior to trial 1, we all got to see unsealed documents that contained communications from the United States Attorney's Office from Massachusetts and the Norfolk County District Attorney's Office. It was there for the very first time that we got to see that the United States Attorney's Office out of Massachusetts did not agree with what the Norfolk County District Attorney's Office was charging Karen Reed with. To quote exactly, they state their office has a very different opinion of the circumstances in this case than as presented in Mr. Morrissey's letter. That is the Norfolk County District Attorney. 3 days after those documents were unsealed, Josh Levy from the United States Attorney's Office told both the Commonwealth and Karen Reed's defense team that they will be releasing their report. It was then 2 weeks later on February 12th, 2024, where the ARCCA experts turned their report over to the United States Attorney's Office. To make note, the Commonwealth and Karen Reed's defense team both had not seen anything yet. That means that no one had spoken to ARCCA yet on February 21st, where 3,074 pages of this report were given to both the Commonwealth and Karen Reed's team. And just as a sidebar, a reminder, the Commonwealth had the opportunity to bring the ARCCA experts on as their own experts. However, they chose not to. Why? Because everything that the ARCCA experts state is the exact opposite that the Commonwealth is trying to state actually happened. The ARCCA experts clearly stated that John's body and Karen Reed's Lexus do not match up. So basically they're using science and physics to state whatever the state of Massachusetts is saying is completely wrong and it's completely impossible. On March 12th, 2024, we had a motions hearing where Karen Reed's defense attorney, Alan Jackson, brings up these exact findings. It was then 10 days later, on March 22nd, Alan Jackson himself reached out to ARCCA to see if they could hire them as an expert. This is where we hear about the email that Jackson sent to Dr. Wolf, where he stated he sent an engagement letter and asked him about the required retainer that they would need. However, Dr. Wolf responded stating that the United States Attorney's Office, who was the people that hired the ARCCA experts, stated that they had to pause and wait to hear back from the Attorney's Office because they were still under contract. That means no payment was ever made. Flash forward to trial number 1, specifically day 22. This might have been one of the more aggravating pieces of the trial. Essentially, what Judge Cannone was stating is that they were trying to bring on experts, the ARCCA experts, but yet they had not had communication with them. They had not gone over anything with them. And she had a problem with that. However, what Janetti had to keep telling her was that they possibly couldn't because the attorney's office told them they couldn't, as well as Bev. So Karen's team was just doing as they were told. And he has to clarify that the only communications that he had with the ARCCA experts was, quote, "We've spoken to them for only the purposes of coordination of their testimony and their background. That's it. We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have." And of course, Judge Cannone had a problem with that and then didn't have a problem with that. 8 days later, on June 18th, 2024, we had a voir dire day. Basically, both ARCCA experts had to come in and state what they knew, state their expertise, and all the like. And guess what? Judge Beverly Cannone agreed that yes, they can testify. On June 22nd, Dr. Wolf emailed Alan Jackson, quote, "a brief outline of qualifications," and attached his DNT list, and basically its do not testify list. In that same email, Dr. Wolf states that Alan Jackson can make whatever changes that he would like. Then 2 days later, June 24th, 2024, both ARCCA experts testified. Another sidebar, because Hank Brennan brought this up in his motion, there's nothing going against giving a brief outline of qualifications, basically his resume, that would disqualify them or get them in trouble at all. They were still following proper procedure. On July 31st, 2024, after trial, the ARCCA contract with the feds expired. It was the fall of 2024 when the Norfolk County District Attorney's Office hired Special Prosecutor Hank Brennan. And on December 4th, 2024, Hank Brennan sent another Tuohy request to the feds, and followed by a subsequent filing on January 6th, 2025, where he stated a notice of intention to exclude ARCCA. And guess what? The feds responded, of course, on January 30th, 2025, and they specifically stated that the Fed statutes and regulation that restrict complete discovery, because it's still an open investigation and they can't give you everything that you want, sir. They are just trying so hard to get this information that the feds are like, no. February 11th, 2025, we got the filing from the Commonwealth stating that they want to exclude ARCCA. In this document, we got clarification that just a few days prior, on February 6, 2025, Attorney Jackson indicated to the Commonwealth that this court that he intends to call experts from ARCCA, and also clarifying that ARCCA and their contract with the feds ended on July 31st, 2024. With a caveat that should either party wish to engage ARCCA for additional analysis, any further engagements must not infringe on any federal privileges. 2 days later, Karen's team sent over whatever discovery or emails that they had with ARCCA. So they complied, and on February 18th, 2025, we got Karen Reed's opposition to Commonwealth's motion to exclude ARCCA. This was filed the same day as that hearing. Now that you all know exactly every single date that everything happened, I'm going to break down exactly why Hank Brennan is a fuckface. And I'm going to show you exactly the reason why hiring a special prosecutor that doesn't read court transcripts, that doesn't know the case inside and out, is very problematic. Stay tuned for part 2.